Okay, we're at the last two options within the real estate transferring uh, into the trust section, this section here. Um, the very last, we're gonna go over prepare the deed to remove a cosigner or a non-owner that happens to appear on title of a client's property. But this last section here, I'm not going to go into great lengths or any major detail. It's here just to do a trust package for a client who doesn't own real estate. Easiest way to give you some tips on this particular option is, or scenarios where that option is warranted, is if a client has financial assets or other valuables, maybe collections or collectibles, but doesn't own real estate and would like to put those financial assets into their trust, then they would do a living trust package, but there won't be a deed transfer because there's no real estate involved. They don't own real estate. And just select this option here and you're good. Um, let's discuss preparing the deed to remove a non-owner or a co-signer from title. Okay, so this option is designed to help a client get their real estate status ready for doing a living trust. If someone purchased a property with a cosigner or refinanced their home with a cosigner and the lender or escrow company required the cosigner to also appear on title of the property as a part of the process of doing the refinance. And then years later, whether they added someone on title for refinancing or they had someone on title from the very beginning to when purchasing the property, and that cosigner initially on the property purchase has appeared on title since the purchase. Years later, when it comes time for the client to do a living trust, they walk into your office and uh, start the process with you and didn't remember that they had a cosigner on the title. That individual needs to be removed from title before we can do a living trust. That person is not a true owner of the property. Um, According to most clients, when they have this type of arrangement, the explanation I get from clients is that that person just helped with the credit, helped with qualification of the loan for more income or better credit. But that person never made a down payment, never helped with a down payment, never helped with mortgage payments, never made property tax payments, never deducted the interest on their tax returns for itemized deductions, never deducted the real estate taxes, the property taxes on their Schedule A for itemized deductions on their tax return. In essence, they just help that person qualify for the loan. And unfortunately, as part of the requirement for refinancing when a cosigner is used, most lenders and escrow companies require that person to also be on title. And so now, years later, the client is ready to do their living trust, or the couple is ready to do their living trust, and it's time to remove that person from title. That will typically create a reassessment situation with the county assessor where that property is located. Especially so if the individual appears as a joint tenant on title and they were on title since the purchase. So let's say a married couple had to use one of the husband's brother-in-law to qualify for the loan. So all three of them on paper purchased the property on paper per agreement between the three individuals, the couple and that cosigner. The cosigner just helped qualify for the loan. They're not an owner per agreement, but legally on paper, that cosigner is an owner. And so when that person is removed from title, it's in essence a transfer of 1/3 of the property to the married couple. So 1/3 of that property will be reassessed at current market value, or at the time of the current market value at the time of the transfer, which is the date of the signing of that deed, removing that person from title. On the other hand, if that person was added to title later as a joint tenant, That's a different situation. So let's say the same couple bought their property initially on their own, no cosigner needed, and then say 10 years later they wanted to get a better interest rate on their loan, and they decided to refinance. But by that time they were already retired and weren't making enough income to qualify for a refinance. So they had to use a niece, a nephew, or one of their adult children, or another member of their family as a cosigner on the refinance. And if that cosigner was added to title as a joint tenancy, as a joint tenant, sorry, then that's classified as original transfers, which are the husband and wife, create a new joint tenancy with that cosigner. That doesn't trigger a reassessment, and neither does removing that cosigner from title years later trigger a reassessment. So reverting to the original transfers from a created joint tenancy with a cosigner, in other words, removing that cosigner from title, if the original owners created that new joint tenancy by adding the cosigner, it's basically going back to the original owners. Therefore, there's no reassessment. So that's good news. That's a really positive thing to let your clients know about. However, if that, again, cosigner was on title since the purchase and then is removed, there will be a 1/3 reassessment. Now, there are certain exemption claims that can be submitted to exclude that from reassessment if the clients have proof that they were the owners and the other individual removed from title was just helping them qualify for the loan to purchase. Proof such as, and this is documentary proof that you must show the assessor with a special claim that can be filed, such as where that down payment money came from, which accounts, um, records of who was paying the property taxes all these years, records of who was paying the mortgage all these years, and really importantly, tax records showing that the husband and wife were taking the full interest deduction uh, when they file their tax returns and the full property tax deduction. The assessor usually requires 3 years of tax returns showing that. And sometimes they ask for the tax returns of that cosigner for the same year, for the same years that the husband and wife are presenting tax returns for, showing that they took the deduction on Schedule A for itemized deductions, just to confirm that none of that interest was shared with the cosigner, where the cosigner also deducted some of that interest. So sometimes they will request the tax returns of the cosigner for those same corresponding years, just to make sure. And then after jumping through all those hoops, they could win that claim and not see a reassessment of their property tax bill. That could go up, geez, $3,000 more every single year. Okay, for a lot of people, that's just painful. So that's how that would. That's the whole concept here, and the potential ramifications of removing a non-owner or a cosigner from title. Um, Now that we know the concepts there, you'd add the name of that non-owner or cosigner, their relationship, okay? And then you get the extra fields that pop up. Is this the personal residence of the client? Address, city, and county where that property is located. And one last reminder, just make sure you format the address correctly per the required address formatting video that you saw earlier in the very beginning of this questionnaire. The state, legal description. Again, if you don't have the legal description, that's fine. Just mention you don't have it and we'll get the correct legal description. Parcel number, and you must upload a photo or a scan of the property tax bill or the current deed, the latest deed showing all 3 individuals on title when the refinance took place or when the purchase took place. Okay, and if another property applies here in this same category, if they have another property where the client's purchased with that property with a cosigner, then add another property and you can do another one there. Okay, that covers pretty much this whole questionnaire. At this point, We hope that you have received good direction, good tips, good recommendations from me in filling out this questionnaire using the concepts that are presented in the concept videos. These page tutorial videos, again, are designed to help you use the new understanding of those concepts that you just gained and applying that knowledge and information to filling out the forms properly. Okay. We welcome you aboard and look forward to seeing your first Living Trust submission. Thanks so much.